Okay, we are on chapter 14. We're going to talk about the third branch of government. And so, just so that we're clear, we have a federal form of government with a national government with three branches: the legislative branch, the executive branch, and the judicial branch. And then we have state governments that are a different level, technically lower, according to Article 6, lower. They have very specific jobs that they are to do and some things that they are prohibited from doing, but they are a different level. So the state governments and the governments of the territories operate separately. But let's look back up at the federal level. Article 1 of the Constitution talks about the legislative branch. And at this time, there are 535 voting members of the legislative branch. 100 of them are in the Senate, 435 of them are in the House, and then there are representatives from several territories that are also there, that also make that $174,000 a year, that cannot vote, but they can debate and they can serve on committees if the Speaker of the House says they can. So they have very specific duties. We find those in Article 1, Section 8, that lays out that they will regulate commerce, that they will take care of foreign relations, that they provide for an army and a navy, that they are responsible for funding, for immigration policy, for copyrights and patents, and maritime law. So a nice array of big jobs that they are responsible for. And the biggest thing is that they make laws. They make laws to make all of those things happen. Then in Article 2, we see that we have a chief executive. The executive branch is headed by a president, one person, and that person's job is to make sure that the laws that have been passed by the legislative branch are faithfully executed. They make stuff happen. And so they are what that has developed into. That developed from a three-man show with George Washington and Thomas Jefferson as the Secretary of State and Alexander Hamilton as the Secretary of Treasury, into this huge bureaucracy with 18, I believe, departments. And we went on to have a defense department, and the most recently created one is the Homeland Security Department. And within each of those departments, there are thousands of employees. And again, their job is to make sure that laws get done. Then we have the judicial branch, found in Article 3. And Article 3 is super short. Article 3 outlines out that really the judiciary was never considered to be a big deal. Alexander Hamilton actually believed that the judiciary would prove to be the least dangerous branch of government. As they were planning the final resting place for the White House, for the president to land and for Congress to land, when it finally made its way to Washington, D.C., they didn't even have a place for the Supreme Court to meet. The Supreme Court would have to go and grab meeting rooms in the congressional halls, and sometimes they would be conducting hearings and they would get kicked out because the members of Congress needed it for a hearing. So, what does the judicial branch, this least dangerous branch, do? Well, they are designed to, number one, preside over impeachments. That's in the Constitution. They cannot set their own jurisdiction. We'll talk about what that word means in a minute. That is set by Congress. Any decision that they make can be overridden by Congress passing a law or changing the Constitution. And the president is allowed to nominate any federal judge from the lowest levels to the highest levels, and they are approved by the Senate. So they don't get to pick the people that they want, and they are not directly elected by the people either. So I have made several trips with my department, and one of the trips that we made was to Philadelphia. And so when when the whole branch, national branch, was created, they initially met in New York. And then they moved everything to Philadelphia. And then eventually, once the White House was built and the Capitol was built, they ended up in Washington, D.C. This picture is of the municipal court building. If you know what that means, municipal means city. So again, the Supreme Court didn't have any place to meet. They would meet in the city court building of the city of Philadelphia. And so when we were doing our tour, we went and we saw this place where when there were Supreme Court hearings, they would be heard. So if you're thinking about it, really, literally, the design of the court was this. There will be a Supreme Court. It didn't say how many justices there would be. Congress gets to decide how many justices there will be. It did lay out what they could hear, but really, literally, their job was to settle disputes. So if there was a dispute, then you would dial up the Supreme Court and they would come and hear and decide disputes. So this went on all the way through George Washington's 2 terms, and then George Washington decided that he was not going to run for another term. He was succeeded by the second president, John Adams, and John Adams lost his bid for re-election after he served from must have been 1796, and then he ran for re-election and lost. And so our third president was a guy named Thomas Jefferson. And Thomas Jefferson was an anti-federalist. He was a big states' rights guy. John Adams was a federalist. And so he had his whole cabinet, and he had quite a few federalists that were in the majority in the House and Senate. So when he lost re-election, that short period of time between when he was getting ready to leave office, he was really, really upset that government as he knew it and as he understood it and as he thought it should be was about to end. So he went about appointing as many Federalists to as many vacant positions as possible. The Congress had passed the Judiciary Act of 1798, and it set forth that there would be all these lower courts, and um, so John Adams was putting Federalists in all these lower courts. It also said that this was the process. You get nominated by the president. The president sends the name over to the Senate. The Senate goes through the process of advice and consent and approves you. And then the Judiciary Act said that the Secretary of State, who at this time was a guy named John Marshall, the Secretary of State shall certify the appointee. So there was no wiggle room, there was no equivocation. Shall. And then it said that if there are any issues, with the appointment and the process, that you take that case directly to the Supreme Court, not to one of the newly created lower courts, go straight to the Supreme Court. The Supreme Court would issue what is called a mandamus, mandamus, a mandamus. And the mandamus would order the Secretary of State to give you your position. So again, it was really, really clear. It said you take these cases to the Supreme Court. Supreme Court, without having to do a whole bunch of thinking, will give you an order and make the Secretary of State issue you your commission. So, John Marshall, the Secretary of State, was appointed by the outgoing lame duck president John Adams to be the Chief Justice of the Supreme Court. He certified himself. And so he was approved by the Senate. He certified himself. And he proceeded to go down the list. They were cranking him out, and he was certifying people. One person that was nominated, and it was for, I think, Justice of the Peace of Washington, D.C., which is not exactly a federal position, but Washington, D.C. was not a part of the state, so they added that to the list of positions that were appointed by the president. And he nominated a guy named Marbury. So Mr. Marbury got his nomination. Mr. Marbury was confirmed by the Senate, but Mr. Marbury did not receive his written commission from the Secretary of State before the office expired. So he had a problem. He didn't have his seal. So the new president took his job. Thomas Jefferson takes his job. He is very, very wary of this Supreme Court with a Federalist that had actually served in John Adams' cabinet as the Chief Justice of the Supreme Court. He would not allow them to convene that first year in 1801. So eventually he allowed them to convene, and one of the first cases that they received in 1803 was a case that Mr. Marbury had signed, because he went to the new Secretary of State James Madison, who would eventually become president of the United States, the third president of the United States, the fourth president of the United States. Um, and Madison was like, "There's no way I'm giving a Federalist the commission." He refused to do it. So he did exactly what the Judiciary Act said. And if you'll recall, that meant you go to the Supreme Court, you file with the Supreme Court, and the Supreme Court shall issue you a mandamus giving the order to the Secretary of State to give you your commission. So John Marshall gets this case. And it really, there was not a lot to think about. Not a lot to think about. In the case, it was really pretty clear that all he was supposed to do is order the Secretary of State, James Madison, to give Mr. Marbury his commission, and that was over. But that's not what he did. That's not what the court did. Instead, he looks at this and he said, you know, I'm looking at the Constitution. And the Constitution has this list of types of cases that the Supreme Court can hear. And so we have the Judiciary Act. The Judiciary Act says that you're supposed to bring it straight to the Supreme Court. But I don't think that the Constitution really allows Congress to have a case come directly to the Supreme Court, basically called original jurisdiction. I don't think that we can do that. So we actually believe that this part of the Constitution, of this law, is unconstitutional. And that's what he wrote. He said, Mr. Marbury, I'm sorry. We are not going to order the Secretary of State to give you your job because we don't think that we actually have the authority to, because this part of this law doesn't work. That decision that something is unconstitutional is called judicial review. This is not in the Constitution of the United States. Constitution of the United States, I'll show you in a minute, says that there will be a Supreme Court, says that jurisdiction of other courts will be set by Congress. It gives a list of cases that the Supreme Court can hear, and then it talks about treason. That's it. There's no judicial review. So basically, John Marshall had just written into existence a new function for the Supreme Court that had not been there before. Now, Thomas Jefferson was in kind of a dilemma because he was happy about this. He was happy that the court said, we don't have to, we can't actually force the Secretary of State to give this commission because we don't have the jurisdiction. But right under his nose, the Supreme Court now had a new function. And that was to look at laws and interpret whether or not the laws themselves were constitutional. All of a sudden, the Supreme Court and the judicial branch had new significance because they had just written in a new check. Now, when you write a law, you have to be real careful because the courts could say that's not constitutional. Oh, all of a sudden, everybody started paying much more attention to the judicial branch, to the Supreme Court, because now they have a lot more power. They eventually built them a Supreme Court building to be housed. And a lot of people say that now, with this power, that the Supreme Court is up on the same level, and in some instances, maybe even a little bit more powerful than at least Congress. And they can actually declare executive orders to be unconstitutional through judicial review. They can declare state laws to be unconstitutional through judicial review using selective incorporation and the 14th Amendment, if you can remember that from chapter 14. This is a picture of John Marshall. This portrait hangs in the Supreme Court. You can imagine why. Because he gave kind of single-handedly, because he wrote the opinion, he convinced the other members of the judicial branch, I believe there were 4 more members at that time, that this was going to be the best thing. And he elevated the Supreme Court to on par at the same level as the other branches of government with that concept of judicial review. Now, he was a Federalist. So we talked a while ago about the case of McCulloch versus Maryland, when the Supreme Court said you can't force the federal government to pay state taxes because of the supremacy clause, and also said that it was okay for Congress to form a national bank because that was regulating commerce. You will see that a lot of the decisions that came out of that court, because of John Marshall's judicial philosophy, a lot of the decisions were national power centered and gave more power to the national government. There were several, but we'll just talk about those 2. Marbury versus Madison, that established judicial review. McCulloch versus Maryland, that established basically that the court was going to be supporting national government over state government rights. So let's talk about, in general, what influences judicial decisions. There are limitations on the federal government, on federal courts. One of the things is that they can't just reach out and make decisions about things if a case doesn't properly come before the court. They can only rule on cases that make it to the Supreme Court. They are also constrained by the facts of the case. Who filed the case? What decisions were made in the lower court? What happened? And so you are limited to what is before you. And so you have to look at the relevant circumstances. You have to look at the specific legal dispute that is in front of you. And you don't get to make commentary on things that are not in front of you. Now, what law do they use? In federal courts, they're going to use the United States Constitution. They're going to look at laws, also known as statutes. And in the American court system, we rely very heavily on precedent. See that word, Precedent, precedent. And the concept of stare decisis. Now, that's a Latin word that actually should be in italics. Stare decisis. And all of this, y'all, comes from England. This is called common law. The English common law system made it into the American judiciary. And they adopted this concept that there are some traditions that we will treat like law, and we will treat legal decisions made by the court like law. And so anytime that you are making a decision, listen to me well, anytime that the court is making a decision and it is on subject matter that has already been decided by the court, the concept of stare decisis, which loosely translated means let the decision stand, says that they are going to follow the decision that was made by the court previously as much as possible. Every now and then, they will decide that they are going to have to overturn something. I'll give you an example. In 1897, there was a case called Plessy versus Ferguson. Plessy versus Ferguson what stood for the concept that the Equal Protection Clause did not mean that facilities could not be separate. So it set up the basis for segregated schools, segregated hotels, segregated restaurants, if the state or local government so desired. So it basically said it's okay to have a separate waiting room at a train station. It's okay to have separate cars for African Americans and whites as long as they are equal. So this was the way, and this set the basis for Jim Crow laws, and basically allowed segregated schools, segregated restaurants, segregated, good heavens, movie theaters, because as long as you had an equal facility, and if you could see me, I have it in air quotes because very, very few were equal, then it was legal. So little by little, litigation started to go through that was looking at whether or not facilities were actually equal. And if they found that facilities were not equal, then they were saying, well, you can't keep that open. You can't keep that open. They were still applying the separate but equal doctrine from Plessy versus Ferguson, stare decisis. So they were interpreting the law to say, if you have facilities that are separate, they have to be equal. And if they're not equal, then you're going to actually have to set up an equal facility, or you're going to have to allow African Americans to actually come to the whites only facility because you didn't follow the law. That went on until a case made it to the Supreme Court in 1954. And it was called Brown versus the Board of Education of Topeka, Kansas. The Brown case decided that by separating schools, and this was specifically about secondary schools, you were setting up children to at least believe that they weren't equal because they were separate. And so they overruled Plessy versus Ferguson for schools, because that was what was before them. Linda Brown and her dad filed on her behalf, and the case went up to the Supreme Court through the NAACP, Legal Defense and Education Fund, and they said, we're overruling Plessy. So we are going, and so they had to explain, this is what the doctrine has been. This is why we think that it is no longer should be good law, and we're going to overturn it. They do it with much angst, much angst. We talked about the line of cases that had to do with abortion, starting with Roe versus Wade as a first right to privacy case for abortion. Anytime any case makes it to the Supreme Court that addresses the right to abortion and states' rights to ban abortion if they so choose, they always will go back and mention Roe. They'll go back and mention Roe. And then there was this case in 1992 that was called Casey, Planned Parenthood versus Casey, that adjusted the law a little bit. It said Roe is still good law. We're going to adjust the law a little bit to say that it's okay to have some tweaks and even some restrictions on abortions in your laws if you want to. You still can't ban it though. You have to make sure that whatever law you pass that has some restrictions is not an undue burden. So now we've established another precedent. And as cases came up, like the Hellerstedt case, that out of Texas, they said, well, we are not overturning anything. In fact, we are applying the Casey rule, and the stuff that Texas tried to do is an undue burden. So that was a tortured way to say that in the United States, we follow cases, and the doctrines that come out of those cases remain in effect until they are overturned. I had a student a while ago, and I want to say that she was from Venezuela, and she was a paralegal, and she was telling me that she just thought it was so strange. She did not understand why, because we hadn't talked about the judiciary. She did not understand why we talked about old cases so much. Because where she'd come from, every case was brand new. They decided that case, and they did not look at old cases. And so it wasn't until I talked about common law that she said, oh, that's why you're always talking about cases, because the judicial system is different in the United States. There is a lot of leeway with justices. And sometimes we find that justices make law. They're not supposed to, but they often do. We can think of Mapp versus Ohio, where they incorporated the exclusionary rule and said now state police, local police, you can't use anything that was illegally obtained against a person. Or the Sullivan, New York Times versus Sullivan case, where they said, listen, if you are filing a libel suit and you are a public official, then you're going to have to prove something other than just that someone said something that wasn't true and it harmed your reputation. You have to now also prove malice and reckless disregard for the truth. So there are times when judges actually set out precedent. Miranda, now police officers have to affirmatively get in writing that you are waiving your Fifth and Sixth Amendment rights. That is law. That came out of the court. So judges do play a role in politics. And there is enough evidence to show that the way that they feel about politics sometimes colors the way that they vote. Not all issues are very clear cut. There are times we've seen quite a few opinions recently where Chief Justice Roberts has said, I don't like this, but this is what the law is, so I'm going to follow it. I don't like it, but this is what the law is. I'm following precedent, so I am going to follow it. Courts have to be real careful that they don't go too far away from public opinion. At least they have up to now. Interest groups will and often do file briefs that explain what their opinion is so that they can let the court know, well, this is what the Sierra Club thinks about this environmental law. This is what the NAACP thinks about this particular case that has to do with the rights of people of color. So they will make comments. The ACLU is probably one of the most prolific amicus writers. And amicus is friends of the court. Just, this is what we think. Don't know if you knew this, but this is what the law is. Here are some examples, and this is how we think you should rule. Congress can come back because, of course, the court's only job is to interpret the laws and determine whether or not something is constitutional. Well, what happens if the Constitution changes? What happens if the law changes? Then you can only interpret what comes out of Congress and gets signed by the president. So really, really think about that. The Dred Scott case, 1857 case, said that people of African descent were not citizens and could not have cases decided in the court. Then the 14th Amendment was ratified, and it said that if you were born in the United States or naturalized, you were a citizen of the United States. So they completely overrode that case with an amendment. So you can't say that it's unconstitutional because that's what the Constitution says. So there are a lot of ways for Congress to get around judicial interpretation. The big hot issue right now is the fact that we have had 6 now justices that were appointed by Republican presidents. And some of it was just a complete refusal by a Republican majority Congress to even acknowledge that President Obama had nominated someone. They just, God's name was Merrick Garland. Antonin Scalia was justice. He passed away in February, and they just never even met. They didn't have a hearing. They didn't even meet with the person that the president nominated. And then President Trump has now appointed 3 justices because one resigned, and most recently Ruth Bader Ginsburg. He appointed someone to fill Justice Scalia's seat that had been held open. Then one of the justices resigned, Kennedy, and then recently Ruth Bader Ginsburg passed away. And so a 3rd justice was appointed by President Trump. So the big stink now is because Democrats don't feel as if this has been completely fair, and Congress gets to set the number of Supreme Court justices. It has not always been 9. We have had as many as 11. We've had as few as 5. We've had 6. That maybe the Congress needs to decide that we're going to increase, that they are going to increase the number of justices on the court, and put some more justices on to make the numbers a little bit more even. And it's called court packing. So if you've heard that at all, that's what they mean, that they may decide to change the number of justices on the court so that if there is a Democratic president, that president can appoint some more people so that it won't be 6-3 anymore on the court. Judicial appointments offer the president and the Senate the biggest opportunity to influence the courts. This lecture with the concept of judicial restraint versus judicial activism. A judge that exercises judicial restraint basically believes that their job is to interpret laws, and to interpret laws only, to apply precedent, to look at legislation, and never to try to create it or change legislation or order that something new happen. Just, this is what it says, this is constitutional or it's not. This is how we're deciding this dispute. That is called judicial restraint. The opposite of judicial restraint is judicial activism. Judicial activism says that there is no reason to assume that the judiciary is not a political actor, and there are some times when the court needs to act to fix what's wrong. And so we saw a lot of judicial activism in the Warren Court. We talked about Brown versus Board of Education of Topeka, Kansas. You have to desegregate your schools. Griswold versus Connecticut created the right to privacy and then started applying it. Miranda versus Arizona created a brand new requirement for law enforcement if they were going to be interrogating someone. Those are definitely judicial activism because they created new requirements and basically new laws through those court decisions. The Citizens United case that decided that corporations are people and that you can't limit how much corporations can donate to a cause because you are limiting their First Amendment rights, because corporations are people too. So now you see those ads and they are super harsh and they spend a lot of money, and then they'll come on and say this is paid for by the people for a greater America. So the politicians sometimes don't even have to run their own ads. The Hobby Lobby case, that was the case where they said that certain corporations were going to attribute the religious beliefs of the owners to the company and say that you don't have to pay for things that go against your religious beliefs. So sometimes the courts make very liberal decisions. Sometimes the courts make very conservative decisions. But we have seen a lot of judicial activism over the years. So I'll end this lecture here.